Well, good morning, everyone. We'll go ahead and get started. Thank you for taking the time to join us for this panel discussion on a very important death penalty topic, access to counsel. My name is Lisa Borden, and I'm a staff attorney in international justice with the Advocates for Human Rights. The Advocates is hosting this discussion in observance of the 18th Annual World Day Against the Death Penalty, which takes place tomorrow, October 10th. There are hundreds of events and activities taking place around the world to observe it. The World Coalition Against the Death Penalty organizes this event annually, and each year chooses to highlight a specific aspect of death penalty practice around the world. This year's theme is access to counsel. The Advocates for Human Rights is a non-governmental organization based in the United States. The Advocates works to implement international human rights standards in order to promote civil society and reinforce the rule of law, and serves on the steering committee of the World Coalition, where my colleague, Amy Bergquist, is a vice president. With support and assistance from pro bono partners, the Advocates also chairs the World Coalition's World Day Working Group. If you want to learn more after hearing today's panel, we'll be providing you with some links to additional resources. You could also register for another CLA program sponsored by the Minnesota Bar Association on October 14th, where Amy, who served as a law clerk for Justice Ruth Bader Ginsburg, will share her reflections on Justice Ginsburg's legacy with regard to the death penalty. We're very pleased to be able to bring you today's event, and I'm really excited about the amazing lineup of speakers who are going to talk with us about access to counsel in the U.S. death penalty. I'll take just a moment to introduce them, and then I'll turn the program over to our panelists. Professor LaWanna Davis, a longtime death penalty litigator with the Equal Justice Initiative in Montgomery, Alabama, is currently a professor at the Cumberland School of Law in Birmingham, Alabama. LaWanna recently became the head of Cumberland's newly established Innocence Clinic. Professor Bernard Harcourt is a professor of law at Columbia University School of Law, and his career-long commitment to representing prisoners in death penalty cases was recently honored with the New York City Bar Association's Norman J. Redlich Capital Defense Distinguished Service Award. Patrick Mulvaney is the managing attorney for capital litigation at the Southern Center for Human Rights in Atlanta, Georgia. Patrick began his legal career at the Southern Center as a Reprieve Fellow, and has devoted his career to death penalty litigation at both trial and appellate levels. He has authored numerous articles and essays on criminal justice and the death penalty. Now I'll turn our panel discussion over to LaWanna Davis.
Well, hello. Thank you, Lisa, for that wonderful introduction. And hello to everyone who is speaking with us about wrongful convictions, about ineffective assistance of counsel, and about the status of the modern death penalty today in anticipation of World Day tomorrow. Today, I'm going to kind of give a very brief talk about some of the systemic things that I see going on with ineffective assistance of counsel. And I'm going to turn it over, of course, to my co-panelists who are going to be speaking about the situations that they see in representation. Both of them are seasoned advocates in this area. Many of you know about the systemic problems of ineffective assistance of counsel and how that leads to death penalty results for people who either should not have gotten the death penalty, some of whom should never have been prosecuted for a death penalty or capital offense, and for those who are also innocent and were prosecuted for a capital offense. And some of those systemic problems that we hear about are very familiar to us. And one of the things that you often hear about are workloads that public defenders' offices have. But I sort of want to talk about even broader or more systemic problems that lead to ineffective assistance of counsel. And one of them is one that is longstanding, but I think will continue and maybe even get a little worse as the economies of states and cities get worse, which is the gap between prosecution and indigent defense funding. It does appear to be increasing. It was already sort of a gap there, but now that disparity seems to be increasing throughout the United States. Some of the studies that we are reading show those disparities anywhere from a quarter less for contract and public defenders up to 75% less for people who are representing folks who are facing capital sentences. And those significant disparities means less resources to the defense and less resources when it really matters, which is at the beginning of a case, when the case is being investigated, when the case is being prepared for trial. And that disparity often is answered by the criminal justice system by saying, well, prosecutors are responsible for all the cases that come into the system, and public defenders and contract attorneys. And contract attorneys, that simply means a system where an indigent defense system will allocate public defense to private attorneys for a contract fee rather than having a public defender system. But at any rate, people will say, well, the disparities don't matter because district attorneys have to do everything and public defenders only have to do one case. And that really isn't what is happening in the United States. The incremental segment of what prosecutors have to do in screening all the cases and handling all the cases is offset by the indigent defense system having to handle cases that many state prosecutors' offices do not have to do. For example, state prosecutors who are death penalty prosecutors generally do not have to handle traffic cases or misdemeanors, and the public defender system has to handle all those cases, not just the felony level cases that many of the state prosecution offices might have to do. Public defender systems also have to train the rest of the criminal defense bar in a way that sometimes prosecutors' office, they have to train their prosecutors, but they don't have to train everybody. But you know, PDs generally, being the experts in an area, have to train everybody. And that burden is sort of a hidden burden that we don't think about when we think about the indigent defense system. Who is going to train all the lawyers who are taking these felony cases, who are taking death penalty cases? It usually tends to be whoever it is that is the, you know, who is the head public defender or the entity that is given the responsibility for indigent defense. In addition, I think we also tend to forget that the indigent defense system has to provide individual counsel to every defendant. A prosecutor can have a conspiracy case and prosecute 11 people at a time in that case. But the indigent defense system, we got to find a lawyer for all 11 of those folks. So we got to sort of remember all the hidden areas where the indigent defense system has to have meet burdens that maybe the prosecution office is able to separate out from or move to another entity. By the way, the indigent defense system also has to provide representation sometimes for quasi-criminal cases. In other words, those people who face involuntary commitment because of sexual offenses, or are going to be placed in a secure mental health facility. It often falls on an indigent defense system to represent those people because they are kind of quasi-criminal things. And so that is one area of, I would say, workload that we have to look at. But also, I think in the United States, and I think around the world, we are also looking at the sort of abdication of prosecutorial responsibility for things that are going on in the criminal justice system. That responsibility is often placed on indigent defense to figure out whether or not there is bad forensic analysts, whether or not there are problematic police officers, whether or not there are system failures within the law enforcement branch of the criminal justice system. And you often don't see prosecutors stepping forward themselves and saying, we're going to look at ourselves and we're going to figure out whether or not there are systemic injustices. We're going to figure out whether or not there is misconduct within our ranks. That is hopefully is changing now with the creation of conviction integrity units, but there are not enough of them, and some of them are severely underfunded, and just like the indigent defense system. And so I think one of the things that if we're going to address this in a systemic way, we have to ask a question that was asked in a recent law review article, which is, where are the prosecutors while all this stuff is going on? Where is their responsibility to manifest justice, secure justice, and rectify injustice when they see it? If we can see it and we can convince courts of it, why aren't they seeing it? And maybe they are, and they don't feel that there's a responsibility to answer some of those things. And finally, I think one of the biggest areas, of course, is the way that ineffectiveness and the review of ineffectiveness has been set up in the court system. And I'm talking about the law, of course. There has always been a judicial reluctance to find ineffectiveness, even in cases of serious deficient performance. And it is, and as one former Supreme Court Justice, William Brennan, said, most courts traditionally have resisted any realistic inquiry into the competency of trial counsel. And you know the old saying, you can't fix what you do not examine. And I think that is the systems that we have within the judiciary, both the almost insurmountable burden to show ineffectiveness and the reluctance of reviewing courts to deal with these claims and instead sort of kind of go behind and just say, well, if there's any strategy that can possibly explain deficient performance, then we will accept that explanation, even if there is not much in the record that actually supports that, or even if no lawyer in this jurisdiction would have done or failed to do what counsel did. And all of these things, in my view, kind of come together to create a systemic problem. And it's a systemic problem that we really are not addressing head on in the criminal justice system, because the people who are most motivated to do so are still fighting the individual battles, right? And that's one of the things that we have to do as lawyers. But I think if we're going to fix this system and fix ineffective assistance of counsel, one of the things we must do is kind of address some of these systemic problems. And interestingly, one of the difficult things is to figure out whether or not there is a problem. And a small thing that could change, I think, in figuring out how big is the problem or what is exactly is the problem, is sort of addressing the unpublished decisions that are being released by the appellate courts, both at the, well, certainly at the state level. Somebody did a study where they looked at ineffective assistance of counsel in one of the states that we think of as being kind of the gold standard for justice, right, which is California. And in that study, they looked at and said over half of the successful ineffective assistance of counsel cases were never certified for publication. And that basically means that you're going to have to really search to find those decisions. They're not going to be in the head notes. They're not going to be easily found through key numbers. So it's an interesting thing that we're doing in the system. And I think we just have to keep presenting to judges, legislators, administrators of the justice system, how the justice system is working against itself to produce results that we don't want. So I'll stop there, because I know we have a lot of great content that are coming from our panelists, including a lot of on-the-ground stuff that they are doing.
Luana, just a couple of questions about things that you mentioned. First, you talked about the contract appointment system for counsel. When people who are appointed to handle these cases and they're not public defenders, are there any requirements for their level of experience or their qualifications to handle these cases?
Yes, we place requirements For example, in the state that I'm in, which is Alabama, there is a requirement of 5 years that you must be in practice. That does not mean it's 5 years of experience with the death penalty, which is a very different question than maybe handling a traffic cases for 5 years, or even handling minor misdemeanors or felonies. One of the things that we all have to remember is that death penalties, because of the stakes that are involved, actually are one of the cases that actually we do see go all the way through the trial system. 95% of the cases around me in this area are guilty pleas, and guilty pleas that are typically happening, sadly, in my view, very early in the process before discovery is even given. So even though somebody may be practicing for 5 years, they may, you could easily practice for 5 years and never have a serious felony trial that goes all the way to conclusion. In addition to that, most lawyers never face a mitigation stage investigation or trial, even if they are doing normal criminal work. So it is a very different thing to step into a death penalty case than to even just do normal work. But given all that, most lawyers are pleading guilty. I mean, most cases are resolved through guilty plea.
Thank you. And this question may be in part for Luana and in part for all of our panelists who may talk about this. But Luana, you mentioned the disparities between public defenders or contract counsel and prosecutors in terms of their training and their, the limitations on what they are required to do. But if you or everyone could talk a little bit more about basically what we think of as equality of arms in general, in terms of the resources that are given for some of the things you mentioned: pretrial investigations, gathering mitigation evidence, obtaining experts, and so on. I know there are some significant issues there as well.
You're absolutely right. I mean, the public defender's office does not have a law enforcement arm to go out and investigate. Whatever is happening for contract lawyers or public defenders, they have to provide either out of their budget or they have to go get themselves. I mean, the law enforcement arm of the prosecution of the prosecutor's office, which is obviously police, they just pick up the phone and say, go get this thing or go interview this witness. For a private lawyer or for a public defender, every time you do that, that's coming out of your budget, that's coming out of your resources, and that's resources that are taken away from other cases in your unit if you are a public defender. I mean, so it is a vastly different situation to be an indigent defender as opposed to being in the prosecution's office. Not only that, but quite frankly, the prosecution's office has the entire state at its disposal. If they have a legal questions, they can call the Attorney General's office. If they have a question about forensic evidence, they can call the local or their state forensic lab. Generally, indigent defenders do not get to order around the state forensic lab. And I'm not saying that shouldn't be so, but I'm just saying that we have to remember that the resources that are available to the prosecution are just so much more vast and not coming out of their budget in the way that it is for contract attorneys and for public defenders.
Now we will turn to Bernard Harcourt. Good morning.
Thank you, Lisa. It's wonderful to be here with Luana Davis and Patrick Mulvaney, who've done extraordinary work for decades now on the death penalty. I want to move from the kind of systemic problems to how it actually plays out when the cases are actually tried. From and Luana Davis did a marvelous job of tracing most of these systemic problems that have to do with inequality and underfunding. And you have to understand that these capital cases are really, it's two separate cases. I mean, it's not only litigating and investigating the guilt phase, but it's an enormous amount of work for the mitigation. And today, in some states where there are resources, we see the kind of work that is required, and it's massive work on the mitigation side, preparing a case. I mean, hundreds of hours of work. The state of the art requires having mitigation experts, and a mitigation workup by mitigation experts can cost up to $100,000 to get all of the documents and all that work. Generally, there are mental health issues in these cases. You might need a psychologist, a psychiatrist, and so when you add up all of that, it becomes an enormous task, which is completely underfunded and therefore doesn't really happen in a lot of jurisdictions. And of course, the death penalty is very variegated across the United States. But I just want to talk a little bit about the experience in the state where I've been litigating for 30 years, which is Alabama. A lot of times these cases, and the reason why I began working in Alabama with Luana Davis back in 1989 at what was called the Alabama Capital Representation Resource Center, not the elegantly named Equal Justice Initiative, right? Was because of inadequate counsel. Of course, those were cases that were tried, some in the late 70s, for the most part, some in the 1980s. And they're the cases that we often hear about today because it takes time for the word to get out, and so you hear about the inadequate representation, about lawyers who were drunk and coming to the courtroom in a state of inebriation or falling asleep at defense counsel. And of course, it takes time for those realities to make it into the public discourse, and oftentimes those were old cases. I mean, folks like Arthur Giles' case. I mentioned Arthur Giles because he just passed away. He was the longest serving person on death row in Alabama, 41 years in isolation. He just passed away of natural causes. But I mean, his case was tried in 1982, or other cases from 87 where there was no mitigation workup, nothing like that. I mean, the first case I worked on with Brian Stevenson was George Daniels' case, where the lawyer had put in 8 hours of pretrial investigation, right? 8 hours of pretrial investigation before going to trial. Now, you have to understand, as Luana Davis was saying, there is no system of defense. In a state like Alabama, there's no system-wide defender service, right? So there aren't trained attorneys who do this work, and as a result, at the time and still today, most of these cases get assigned to local attorneys who don't have the experience. There aren't many death penalty cases in some of these counties. And so it's somebody who basically has never had a death penalty case, doesn't understand what needs to be done. That was certainly the case in Dole Ham's case, 1987 trial, no mitigation workup whatsoever. 2 witnesses, one of them was literally 2 pages of a trial transcript. It was just a prison guard to say that he'd been okay during his time in jail. The other was his sister in a monosyllabic kind of 19-minute presentation, said absolutely nothing, and actually said that it would be good if her brother was sentenced to death, if that would help the family. So I mean, but of course that was oftentimes people say, well, that was the old days, right? And what I'm here to say is, it hasn't changed. Surprisingly, it just has not changed. And so, I just took a case, I got appointed back in January in a case, a new death penalty case. It was actually tried in about 2008. And tried down in Dothan in Houston County. And I'm not going to use any names here, but let me just tell you a little bit about this, right? This is in other words, this is a fresh case, right? First of all white jury, right? So you've got That's in violation in the prosecution of these cases. Of course, it was the same prosecutor who's been doing this for years, actually. It was a case, the same prosecutor who had been doing this back 30 years ago in another case I had down in Dothan. But let me tell you a little bit about defense counsel. It was an older gentleman was appointed with no real death penalty experience. During the 1 year between his appointment and the start of trial, he had open heart surgery and cataract surgery. And in addition, he went through a divorce and was ordered to move from his home the very week of the trial in this case. Okay, so that's just to give you a little bit of a background, right? You know, someone, think about this for a minute, right? You're facing death, you're going to trial, and your attorney has to have open heart surgery, cataract surgery, and gets divorced and moves out of his home the week of your trial. Now, what are you thinking? How are you feeling? How are you feeling about this, right? I mean, this is an attorney who comes into the courtroom having filed motions to exclude and who says to the court, this is a quote, "Before I went in for heart surgery, I'd only looked at the cases before I went in for heart surgery, so I'm not aware of any new cases. There may be, but I'm not aware of any." All right? This is an attorney who literally on the record is telling the trial court, I have cataracts in both eyes and I'm going to have surgery on that. And if I was to have to tell the court that I could not read a normal piece of paper, that would not be an exaggeration. In fact, looking at you right now, Judge, all I see is a blur. Okay? All right. So this is the attorney that you have. Well, now let me tell you just a few things about what happened at the trial. Okay? Counsel waived closing argument at the guilt phase. Okay, just think about that for a second, right? Counsel waived closing argument at the guilt phase. I mean, there is no possible way in which that could be a reasonable strategic decision by an attorney in a death penalty case. If you want to concede guilt, for instance, then have your closing, concede guilt, try and use that towards some mitigation at the penalty phase, right? I mean, there's nothing conceivably reasonable about waiving a closing argument, right, after the prosecution has made their fullest argument at the guilt phase. Okay. I mean, now, of course, the state will argue that there are all kinds of strategies involved. In this case, the older gentleman who sadly has passed away very shortly after the trial, had the client kind of waive his right to the closing argument and make all kinds of statements to the effect that he was kind of protecting the attorney from this, from what would be clearly ineffective assistance of counsel. He just closed with I mean, there's no place anywhere that a paid attorney would do this. No one who is paying their counsel would accept this kind of representation, and not a single person listening to this, not a single judge ever accused of anything would accept this kind of representation, and yet this is what we have. Another thing, the attorney, in part because of his cataracts, never investigated the fact that there is a incriminating letter written by a co-defendant in this case. That letter has never been released by the state of Alabama. Now, apparently, there was a mention of the fact that the co-defendant, when in jail, had written a letter that essentially took responsibility for the murder. So there was a mention of that in the police reports. If the attorney had read the police reports, the attorney would have said, that letter could be helpful. Let me see it, right? I mean, this is This is a confession by a co-defendant that she was the one who committed the murder. I mean, I don't know how to convey this, but it's not bad practice. It's not ineffective assistance of counsel. It's some form of it's some form of criminal negligence, really, not to get that letter, which at this point has never been turned over by the state, because now there's this idea that, well, there was some mention of it in a police report. Trial counsel should have gotten it. Trial counsel didn't. So at this point, it's all procedurally barred, essentially, right? Which are the technical rules that apply in these death penalty cases, okay? But somebody is sitting on death row with an attorney who failed to even get the co-defendant's confession, right? Okay, new case. This is what's going on right now. Penalty phase, counsel called 2 witnesses again, right? No different than back in the 1980s. 2 witnesses in mitigation. No mental health experts, no mitigation expert, nothing, none of the workup that we would expect in even in the most basic death penalty litigation. So now, you know, this is how those systemic problems that LaWanda Davis was trying to tell us about and clarify and explain play out in these individual cases. You know, we've seen differences in different jurisdictions. I hope Patrick can give us a little bit more optimistic view of what's going on in some areas. But in many jurisdictions, basically, nothing has changed in 30 years. And you've got essentially the worst kind of representation in the most important cases.
Thank you, Bernard. A couple of questions for you. I know that early in your career, as you mentioned, you worked with what's now EJI in Alabama, along with LaWanda. But since that time, you have handled a number of death penalty cases on a pro bono basis. And I wonder if you could just comment on the role of pro bono assistance in death penalty litigation in the U.S. How important is pro bono representation?
Right.
Does that fix the problems in terms of inadequate counsel representation in death penalty cases, or is it just a stopgap?
You know, it's extraordinarily important, and we need much more of this kind of pro bono work. But it is a stopgap. That's really all it is. It's a Band-Aid. We're dealing with a problem that has large systemic roots of inequality, of unequal funding, and many times it's too late by the time you get into these cases, really, to do much. And that's the biggest problem. So I mean, the pro bono help, and there are many firms that have been doing extraordinary work in this area and dedicating a lot of resources and attorneys, and that's really important. But you have to understand, it's often, sadly, and there are many successes, but it's a little bit a day late and a dollar short, right? Because basically you're coming into these cases, like the case I was just talking about right now, right? Where the issues are procedurally defaulted. There wasn't if the work isn't done at the trial level with the proper objections being made and raised and things being litigated properly from the beginning, the American system of review is one of a kind of a procedural quagmire that allows a lot of steps of supposed review, but that are procedurally barred effectively. So you're never getting to the merits of these claims. You're spending years litigating whether or not you can litigate an issue. We're going to spend years litigating whether or not we can litigate that failure to disclose the exculpatory statement by the co-defendant, right? And that's the way the American system works, in a sense, that those are the procedural bars, AEDPA, which was passed in 1996, was this kind of procedural hurdle that prevents us from getting to the merits of these issues. And so the pro bono work is really important, but it's really a kind of sticking your finger in a dike.
And we also mentioned a little bit the very high bar for finding ineffective assistance of counsel in post-conviction proceedings. If Congress were to rewrite the Strickland standard for determining when counsel was ineffective, what should the standard be?
Well, the first point is you're entirely right that Congress has control over all of these issues, right? In other words, they write the way that habeas corpus works in the courts. They establish the standards, right? And so you're entirely right that when we talk about these problems, we're often talking about the courts and their interpretation and their rulings, but all of that could be fixed. In part, all of it was broken by AEDPA. All of it could be fixed by Congress. Okay, and so that should be a priority. That should be a priority of a democratic Congress, would be to fix habeas corpus. Now, and how would they set the standard? Well, I think in this country, the standard should be what you would expect from a properly trained, well-paid attorney, because there's absolutely no justification whatsoever for different kind of representation because you're poor. There's just no justification for that. And so the standard should be, we should look at what a well-trained, well-compensated attorney would do in any of these cases. And if we did that, right, at least in the cases I've litigated and in the jurisdictions I've litigated, about 95% of these cases would just not meet that standard. All right, and I'm being generous here. It's probably 100%. Thanks.
Thank you, Bernard. And now we will turn things over to Patrick.
Thank you, Lisa, and thank you to Professor Harcourt, Professor Davis. I have had some experiences similar to the experiences that Bernard, Professor Harcourt described. One of the first capital cases that I worked on, I remember going to look at the transcript from the case, and after the point at which the state made its case for a death sentence, the judge turned to the defense table and said, okay, time for the defense. Now, this was the chance for the defense to show the jury why the client's life should be spared and why the death penalty should not be imposed. And the next line of the transcript comes from the defense attorney, and the line is, quote, "Nothing for the defense, Your Honor." That was it. Similar to what Professor Harcourt was describing about just not even making an argument. This was at the penalty phase when it was time to make the case, to present evidence for the client's life. And that was it. And then a death sentence was imposed. And what's so striking about it is that there was so much there. There were so many reasons why this young client's life should be spared. It was a case in which the client was 18 years old at the time of the offense. It was a case in which the client's co-defendant had shot two store clerks during a robbery. The crime was on video. It was very clear that the client was not the shooter, not the person who committed the shooting. The client had been abused and neglected repeatedly as a child. And despite his struggles as a child, he'd shown a ton of compassion in his young life for other people. And despite all that, nothing for the defense, Your Honor, was all that was said when the question came as to whether this young man would receive a death sentence or not. And that case was tried in the late 1990s, which was really the height of new death sentences in the United States, if you look back over the last 50 years or so. And I agree with Professor Harcourt that we still see some of those same problems in capital cases today. However, at the same time, we also see some positive signs. We see positive signs in some cases, in some places. We see positive signs both with respect to access to meaningful counsel, and we see positive signs with respect to declining new death sentences. And I think those two categories of positive signs are directly related. Just to take us back to the late 1990s for a minute, there were about 300 new death sentences imposed each year in the late 1990s. So in a given year, about 300 people would be sentenced to death in trial courts across the country. In recent years, that number has been about 40. So there have been about 40 new death sentences a year nationwide in recent years. And I don't want to oversimplify. There are many factors that go into declining death sentence numbers, but I do think that one key reason for that decline is improvements in access to counsel in certain jurisdictions. To take Georgia as an example for a moment, from 1995 through 2000, there were 49 new death sentences in Georgia. So in that 6-year period, there were 49 people who were sentenced to death in Georgia trial courts. From 2015 to 2020, that 6-year period, there's been one new death sentence imposed. That case was imposed, that sentence was imposed in a case in which the client represented herself and didn't say anything at the trial. And so when we look at that decline, again, there are a number of factors at work, but one thing that is important to acknowledge about Georgia is that about 15 years ago, Georgia passed some reforms to its indigent defense system, including that a capital defender office was established. So this is an office that has specialized trained attorneys who focus on capital trial cases. And the office has done excellent work. And so in the ordinary case, instead of a randomly assigned attorney who may or may not have capital case experience, the default in Georgia is that the Office of the Capital Defender would get involved. And what I want to emphasize, we're talking so much about counsel, but as both of the prior panelists also noted, we're using counsel here really as a shorthand because these cases are done in teams, and it's so important that it's counsel and investigators and experts. But in recent years, when we with these reforms in Georgia in recent years, we're seeing substantially fewer new death sentences being imposed. And Georgia is not alone in that. There are some other states that have followed a similar path. In Virginia, for example, which is another state that historically had many death sentences have dramatically declined there as well. And there have been some similar reforms in Virginia that have contributed to that. And so I think, looking at a state like Georgia can really help show that providing access to trained and experienced capital defense counsel, specialized counsel who focus on capital cases, can really make a difference. When we have an attorney who comes in and says, "Nothing for the defense, Your Honor," when it's time to make the case for life, we can expect more death sentences will be imposed, and that's what happens. When we have a system where there are dedicated capital defense teams that have access to resources and investigation and experts, we can expect to have, I think, fewer death sentences and fewer of those situations that are so problematic, where a human being is standing at defense counsel and counsel is saying, we don't have anything to say about why this person should live instead of die. The one other thing I would note is that when we talk about good counsel and talk about good teams, I think it's important to emphasize that this is not just about legal skills and the ability to call witnesses in a courtroom or anything like that. What we also really need for the system to function properly is capital defense attorneys who really stand up for the dignity and the humanity of their clients. And I had the privilege years ago, this I think was about 9 years ago, of working on a capital trial case with Steve Bright, who was the director of the Southern Center for Human Rights for many years and is really an incredible attorney. And I just want to share one story about a trial case with Steve, because I think it helps illustrate what I'm talking about here. We were working on a case. It was about 2 hours south of Atlanta, and our client was Jamie Weiss, and we got to the penalty phase of this case, and the district attorney stood up at the end of court one day and said, "Judge, I want to make a motion. I move for the defendant to be brought into court tomorrow in a jail jumpsuit. He's been coming to court in a shirt and tie every day, but now that the guilt phase is over and we're at this penalty phase, our position is that he shouldn't wear a shirt and tie anymore. He should wear a jail jumpsuit, and I don't see any reason why he needs to wear a shirt and tie to court." And I'll never forget how quickly Steve jumped from his seat, and he said, "Judge, the district attorney just said that he can't see any reason why Jamie Weiss should wear a shirt and tie to court tomorrow." Well, I'll give you a reason. You see, there's a thing called dignity. And when people come before the courts of this state, they should be treated with dignity and they should be treated with respect. Now, Jamie Weiss is a young man from West Virginia whose life is on the line in these proceedings. His life is on the line. And when we come to court tomorrow, the district attorney is going to be wearing a shirt and tie. And I'm going to be wearing a shirt and tie. You, judge, are going to be wearing a shirt and tie, and the sheriff is going to be wearing a shirt and tie. Now, if we're all wearing shirts and ties, then certainly Jamie Weiss, this young man whose life is on the line, should be wearing a shirt and tie too. And you could hear a pin drop when Steve sat down, and two things were immediately clear to everyone in the courtroom. The first was that Jamie was going to wear a shirt and tie the next day. The second, though, was much more important. The second was that if anyone was going to try to dehumanize Jamie Weiss, then Steve was not going to stand for it. He was going to stand up and make sure that didn't happen. And I think when we look at this issue of counsel in death penalty cases, what we really need and what we hope for as we move forward is that all capital cases have counsel who have the necessary training, the necessary resources, the necessary experience, and also the real willingness to stand up for the dignity and the humanity of their clients. And where we have that type of representation in a given case, I think a death sentence becomes far less likely.
Thank you. I just want to remind the attendees that if you have a question for any of our panelists, you're welcome to use the Q&A function. A few questions about your remarks. You mentioned that death sentences are declining, and some people may be tempted to say that this shows that the system overall is improving and really focusing on the worst of the worst cases. Is that your experience?
No, that has not been my experience at all. When we look at what those 40 cases are in the nationwide, they are, and it's completely arbitrary in terms of which cases wind up. I shouldn't say completely arbitrary. There's so much arbitrariness, but there are also determining factors that are improper factors. And one of them, of course, is counsel, and then issues of race and politics play a key role. But the idea that those 40 cases are the worst or the most deserving is not at all the reality of what happens. You have certain jurisdictions where, for one reason or another, the state believes that seeking death at a given time is appropriate, and then you have these systemic issues about whether defense counsel are funded that play a huge role. And we've seen over the history of the death penalty in the United States how big a role race can play. And so it's the combination of those improper factors and just total arbitrariness that lead to those death sentences. But the idea that somehow the system has gotten better and we're identifying the cases that are somehow most deserving, that's just not what's happening.
Can I add something there just quickly, Lisa, before your next question? I mean, it's really important. I mean, you can't really compare the 1990s to today. It's a little bit like apples and oranges, because 1990s, we were at the peak of homicide rates in the United States. I mean, so we live today at a time in which, our homicide, mercifully, right? We've seen an extraordinary decline in crime in the United States since the 1990s. Mercifully, we're back to periods which were almost predated the 1960s in terms of the homicide rate. So when you look at the curve, I mean, you got to realize that, part of this is, I agree, some jurisdictions that have been able to implement better access, but you also have to understand that, this is a tenfold declines in crime that mean that we live in a much safer America than we did in the 1990s. And that's something just to keep in mind as well as we think about what's going on, because the need for the claims of deterrence, et cetera, have almost vanished given these enormous crime drops.
Thank you. You also mentioned that.
Lisa, I think your mic is off.
Mm.
Okay, that works.
Yeah, I was not muted, so I'm not sure what happened. You mentioned that there had been very few new death sentences in Georgia in recent years. Is Georgia still carrying out executions?
Yes, one issue that is coming up with some frequency now is this question of when, as Professor Harcourt mentioned, cases sometimes take some years to get to the point at which the state can seek an execution warrant. And we've seen cases in Georgia where the state is still seeking executions. And so there have been quite a few executions in Georgia in recent years. There have been, I think, in the last 5 years, 15 or so, maybe even more, between 15 and 20 executions in Georgia, while there haven't been new death sentences, or there's been one new death sentence. And that's a troubling, those are troubling numbers, because really what it suggests is that we're executing people, we're killing people who very, very likely wouldn't get sentenced to death today in Georgia. And that's a real problem. There are a lot of problems with that, but it's a concern that the states are continuing to plow ahead with executions in this environment.
Lisa, if I may, you may have another question, but I just wanted to make a comment about these cases. I think that some of the people who are looking at this may be thinking, well, it's a very narrow sliver of the criminal justice system to be talking about death penalty cases, or even to be talking about innocence cases. because so many cases are being resolved through guilty pleas, often the kind of cracks in the criminal justice system are not revealed until you get these cases that are actually being tried, that are actually being taken through the entire system. And many of the things that have been overturned in the criminal justice system or been challenged in the criminal justice system, forensic, analytical junk science, all of these things, a lot of these things came through attacks or I guess challenges in death penalty cases and innocence cases, because those are the cases that tend to be, fought hard. They tend to end up in post-conviction in ways that the majority of criminal justice cases today that end in guilty plea, we don't even look to see if there are bad snitches. We don't even look to see if there are eyewitness and misidentification. We don't even see whether or not there are forensic problems. And so that's why I don't think that it's wrong for us to delve into these areas, because these are the areas where we get to put the criminal justice system to its real test, by getting the discovery, taking this case through trial, really putting the government to its proof in a way that it is not for the vast majority of criminal cases. So I just wanted to point that out. And unfortunately, you are muted again. No, we cannot hear you.
There we go.
Can you hear me now?
Yes.
Perfect. I don't know what's going on. I just won't mute myself again. I was saying that I think the death penalty and lack of access to counsel at the outset of cases, as you mentioned earlier, also plays a really large role in all of those guilty pleas, doesn't it? Because many, many people are pleading guilty because they are being threatened with the death sentence unless they do. So that's probably where we're missing a lot of the issues that you're talking about, because people are pleading guilty early when they haven't had good counsel and they're being pressed with the death penalty. We've talked a lot about the issues that get raised in post-conviction litigation, and I guess one question I have is, how do people get counsel after their direct appeals are exhausted, when they're raising these issues of ineffective assistance and other kinds of constitutional violations that might have happened in their trial proceedings?
Well, I think it's thanks to folks like Patrick Mulvaney and Luana Davis, who recruit lawyers for these cases. It's thanks to the Southern Center for Human Rights that recruits lawyers, and the Equal Justice Initiative that recruits lawyers. Now, there are, in some jurisdictions, there are CHUs that are capital habeas units that will take cases in federal post-conviction. But the big gap is often the state post-conviction. Alabama's Rule 32 has different names in different states, but where there really isn't a provision. And really, it's thanks to Patrick and Luana and all the folks at the Southern Center and Equal Justice Initiative that lawyers are recruited to take these cases at those stages. But maybe Patrick and Luana have more to say about that.
Well, go ahead.
I would just add briefly that there are certain states, as Bernard mentioned, that have where there's a federal public defender capital habeas unit. There are other states that have state post-conviction offices, but it is we are fortunate that many private attorneys at firms do get involved in post-conviction cases pro bono, and There is always a real need for more in capital and non-capital cases alike for attorneys who can come in and work up the cases and have the resources and time to do it and to litigate them. And so we're always looking for attorneys to volunteer their time to get involved in this type of case. And so I would just encourage anyone who is interested to reach out to our office.
Yes, and I will just add to that my first foray into death penalty litigation in 1995 was through the Equal Justice Initiative, who assured me that they would teach me everything I needed to know about death penalty litigation. And Luana Davis was the staff attorney that oversaw me in that case and did a wonderful job of indeed teaching me everything I needed to know. So for attorneys who are listening who might be interested in getting involved in that, Equal Justice Initiative or the Southern Center are great resources for that and would provide all of the resources that a lawyer needs to be able to understand the complexities of this litigation. Would you say that there's anything else that attorneys who are listening today could do to help address the problems that we've talked about? For example, in terms of legal reforms or otherwise.
Yeah. I mean, I'm gonna try and be quiet, but I mean, what Luana was talking about in terms of the systemic problems here are issues that need to be addressed at a governmental level, and few are as well equipped as well-trained attorneys to do the kind of work and the kind of interventions and the kind of talking to legislators and presenting and talking honestly. I mean, as an attorney, someone who has been in the courtroom, someone who knows what this is all about, they are the most important people to lobby for these kind of changes. Luana?
I agree. And by the way, there was a question in the Q&A about if we had a perfect world in which Congress would listen to us about changing some of the legal standards, and in particular the Strickland standard, I would say that I would change the requirement that a defendant has to show that the ineffectiveness was outcome determinative, because it's a requirement that is unusual in the law in terms of that the defendant has to then bear the burden of showing, okay, except for all these terrible things that happened, I would have been acquitted. I just think it's an impossible burden to show that kind of but-for causation. And there are other tests, including the test that is in New York, which is basically a fairness of the process test, rather than you show us now that all these terrible things happened in your case, that you would have been acquitted. And so I'd probably say if I had my druthers, I'd probably say, hey, why don't we evaluate these cases as a whole and evaluate them according to the fairness of the process that we say we are giving to criminal defendants.
Thank you. Well, we are out of time. And I just want to thank all of our wonderful panelists. This has been a really fascinating discussion. Again, World Day Against the Death Penalty is tomorrow, and we provided you in the chat with some resources where you could follow up to learn more about a number of these topics. And thank you to everyone for joining us today. Have a great day.
Thank you, Lisa.
Thank you.
Thank you, Luana and Patrick. It was great to be with you.
Thank you so much. I've learned so much from you guys. Thank you again. And thank you, Lisa, for the opportunity, and to the advocates as well.
Thank you very much.